Welcome to the Legal Lounge here on CRN Digital Talk Radio, CRNTalk.com, streaming live coast to coast and around the world on CRNTalk.com. Also available in stunning high-definition video on Facebook.com/CRNTalk. Also on CRN's custom-built Roku channel, streaming live there right now, TikiLive.com, and of course on CRNTalk.com. I'm joined, as always, by the one and the only, an active attorney, U.S. Army veteran, Juris Doctorate in law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, America, An Illusion of Freedom, is available on Amazon, Barnes & Noble, and on iTunes. You can check him out on AM 870 The Answer. Ladies and gentlemen, Mr. Richard Nixon, and the show that gives you the news you get nowhere else. How are you, Richard?
I'm pretty good. I started off today, though, thinking our first issue might be tariffs. And then I got struck by something else that I saw. I actually saw, I didn't mention this pre-show, Mike, but I saw Benjamin Franklin on PBS, his life and his accomplishments, and I was really struck by what an absolutely fantastic man he was, just unreal. And maybe some other time we'll go into some more details, but it made me think, because of what he said before he passed away, is that there is something more important than, for instance, my title talks about America, An Illusion of Freedom. There's something more important than freedom and or liberty. And in my mind, suddenly, I don't know, I probably known this all my life, but certainly what's come to the fore is the idea of truth. And as a lawyer, I have done considerable research on, if you will, the lack of, by many cases. Most of these cases, I say, are the result of our Supreme Court misinterpreting some of these things called doctrines. And what do you think about that
Doctrine,
idea?
yeah, I mean, I've always learned, from when we first started doing this show, that doctrines and tests are all court-made.
Exactly.
And you and I actually both recently watched another great PBS documentary on the Roosevelts.
Exactly.
And you have Teddy and Franklin,
right.
Teddy being a Republican, Franklin being a Democrat, and how both really thought that the Constitution was a living and breathing document, and
Correct.
appointed justices that thought the same.
Right.
And so, we're going to talk a lot about that in this coming hour, to talk about truth, about the Constitution as a living, breathing document, or actually a stated set of principles that the founders spent a lot of time and a lot of thought putting together. And so I think that's going to be quite fascinating because, like you said, Richard, your book, America, An Illusion of Freedom, which is available wherever fine books are sold, it talks a lot about how 9 justices sitting high up in robes make these doctrines, make these tests, and usurp the will of the people being the legislature. So we're going to talk more about that after the break. We're going to get into something, another kind of interesting compare and contrast between two Supreme Court justices, Justice Thomas and Justice Brennan. So stick around, you guys. We're here in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. Stay with us.
Hi, everyone. Tom Mustin here for the Legal Help Center. If you've been injured in an accident and think you deserve compensation, listen up, because we have legal professionals standing by right now to answer your questions for free. You'll find out if you have a case and how much it's potentially worth. Call 800-745-9090. That's 800-745-9090. The call is free, the consultation is free, and you could speak with a live agent right now. So, if you or someone you know were injured in an accident, like a car accident or slip and fall, call now to find out if you have a case and how much money you could potentially get. 800-745-9090. That's 800-745-9090. Advertisement sponsored by Legal Help Center. May not be available in all states.
And we are back in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. As always, all past and previous sessions of this high-quality broadcasts are available on YouTube, also on Rumble. Find CRN Digital Talk on both those platforms. And Richard, you pointed this out to me. This is a fascinating article written by the Daily Journal.
Yes.
The title is "From Liberal Lion to Conservative Stalwart, Clarence Thomas Passes Brennan." And of course, this has to do with the fact that Justice Clarence Thomas, friend of the show,
Yes.
he has now become one of the longest tenured justices on the Supreme Court. And I believe he's number 2 or number 3 at this point, but he has passed liberal lion, and I use those in quotes, Justice Brennan, and kind of compare and contrast these two, their different philosophies, Richard.
Yes, well, just very briefly, the attorney's name is John Scherer, Scheerer. No, I got the wrong article, Mike. I'm sorry. From Liberal Lion. Oh, yeah, thank you. But we're going to have to. I'm sorry, but I got the wrong thing here. Yesterday marked a milestone on the U.S. Supreme Court, a passing of the ideological torch through the measurement of time. Clarence Thomas, the most enduring conservative voice on the bench, has now officially surpassed Justice Brennan, the liberal lion of the Warren Court. Brennan served 12,000 plus days. Thomas reached that figure on Saturday and has passed him. Now, Thomas sits as number 7 to continue going on, and eventually we will talk in the next segment about their basic philosophy. Not only is Thomas set to pass a number of other justices, but we have to talk about their philosophy.
The philosophy being that one of the themes of this today's show is the living, breathing document versus the text, the originalism. I guess that those are two kind of competing visions that you see in jurisprudence: the living, breathing document and the strict constructionalist.
Right. Well, appointed by President Dwight Eisenhower in 1956, Justice Brennan came to embody the liberal jurisprudence of the mid-20th century. A former state judge from New Jersey and devout Catholic, Brennan nevertheless became the intellectual and moral engine behind many of the Warren Court's most ambitious rulings. One, the incorporation clause, which I disagree with. He championed expansive interpretation of the Bill of Rights, particularly on free speech, due process, equal protection. That's the 14th Amendment right there. And criminal defense rights. Brennan believed the Constitution, here we go, was a living, breathing document, a character made to be interpreted considering modern values and evolving social norms. So from this point, as far as my position goes, once we allow the courts to exercise that jurisdiction, there really is no limit to what the courts can do. And in particular cases, he wrote that for the majority, sex discrimination in Showan was taboo. And even in the Eisenstedt versus Baird case, he expanded on Griswold, allowing unmarried couples the right to contraception. Now, he would say oftentimes, with 5 votes, he famously said, you can do anything. And then from then, we might want to talk about something about what Justice Thomas's position is.
Please. Yeah, what was Justice Thomas's position?
Okay, very good. Justice Thomas, he was, if you will, a ideologue as opposed to a tactician. Now, that's according to Mr. Kingsley here. Yeah. He was nominated by President George W. Bush it was the father. It was H.W. Bush. He arrived amid controversy, and he sat quietly for many years, and finally became louder and louder and more influential. To Thomas, the Constitution means what it meant at the time it was ratified. Bravo! He is deeply skeptical of precedent if it strays from the foundation. He is written alone when necessary, unmoved by consensus, and so on. Thomas has consistently pushed the court further to the right. Even if in agreement with the majority, his concurrent screams of radicalism. This is the summary here. One such example comes in Dobbs versus Jackson. That was the case that found, according to Alito's writing, that the Constitution, the right to an abortion is not a constitutional right. The right was sent back to the states where it belonged under the 10th Amendment. However, Justice Thomas, in this particular case of Dobbs versus Jackson 2022, said, in further cases, we should reconsider all the court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. And I think my partner here will have something to say about substantive due process.
Yeah, I mean, substantive due process versus procedural due process.
Exactly.
Where procedural due process, correct me if I'm wrong, is just the letter of the law of various things, and substantive due process is whether it's right or wrong. Is that?
Well, okay. The way I look at it is, if you just take a simple example of a person driving a car through a stop sign, the police officer stops him, gives him a ticket, the guy signs the ticket, tells him he's got to be in court in 30 days and so on. That is all procedure. That has nothing to do with, quote, the penalty, if any, that will result from his going through the stop sign. So that's strictly procedure. Substantive law is where you research the case that you violated, 1.256 point of the vehicle code. You check that out, and it says, if I'm found guilty, I could spend a day in jail and a $500 fine. I'm just making these numbers up now. But that is the substantive law, as opposed to the procedural law, which basically says that you have this particular procedure. Now, the reason that is critical to make the difference is this. The 14th Amendment says that no state, this is 1868 now, no state shall deny a person of life, liberty, or property without due process. Notice, we're talking about procedure. So what is the Constitution, 1868, the 14th Amendment, Due Process Clause? What is it saying? It's saying that heretofore, no state shall deprive a person of their life, their liberty, or their property without due process, which simply means the states must have some kind of procedure set up if the state is going to deprive a person. Remember, it's any person. It doesn't matter if it's citizen or otherwise. But if that person is going to be deprived of his or her life, liberty, or property, there must be some procedure, some due procedure. What they mean by due procedure is this. The procedure necessary for going through a stop sign might be X, but if you're being held for X to being a serial killer, certainly the procedure is much more involved. So that's what we mean by due procedure. Whatever procedure the state determines is sufficient or due that particular offense. Again, we're only concerned with the procedure. The Constitution is not getting involved in what the substantive law is for these particular states, only that they must have some procedure. At that point, we hold up.
Substantive due process, substantive laws are kind of...
It's an oxymoron.
It is. It's trying to find something not outside of the statutory text to protect fundamental rights.
Exactly. And so what they're saying basically is not only must the state set up some kind of procedure to have punishment for these different people, to apply the due process clause, but we're going to tell you what the punishment should be like. Again.
Yeah, they also have to make up something because it's outside the text. Well, I thought Richard will be right back after the break. Stay with us.
People in California, inflation and crime. Hi, Aaron here. We at California Deluxe Windows addressed both. We are making beautiful energy-efficient custom-fit windows right here in LA, saving on waiting time and the cost, so it beats inflation. And our security features are unlike anybody else. Steel-reinforced frames, metal cumlocks, night latches made from Lexan, almost unbreakable, like a football helmet, interlock, and more. This is our deflation security cell with 30% discount on top of it. And our installation is so precise, we do not break your stucco. Your house can be covered with potato chips and we wouldn't crack one. Call us 866-988-5100. 866-988-5100. 866-988-5100.
CSLB 7745518. Some restrictions apply.
Savor the past and savor the glory days of Las Vegas. Enjoy 70 years of true Las Vegas history as 4 generations of family wait to greet you at the legendary Bootlegger Italian Bistro. Wine, dine, and experience Mama Maria's award-winning original recipes while surrounded by original family photos and celebrity memorabilia. Enjoy piano artistry nightly with music from the Great American Songbook in our main formal dining room. The Bootlegger Italian Bistro, 7700 Las Vegas Boulevard South. In the entertainment capital of the world, the Bootlegger Italian Bistro, open 7 days a week. 7700 Las Vegas Boulevard South, in the entertainment capital of the world. It's Vegas, baby.
Are you ready to make a difference for the environment while helping the visually impaired at the same time? Then donate your vehicle to Heritage for the Blind today by calling 800-785-9618. Every donated vehicle will either be properly recycled in an eco-friendly manner or given a new life through reuse. Donating your vehicle is easy. Simply call 1-800-785-9618 and Heritage for the Blind will do the rest. They'll even arrange for your vehicle to be picked up at no cost to you. And for a limited time, when you donate your car, you'll receive a $200 restaurant voucher and a 2-night, 3-day hotel stay at one of 50 locations. Call 800-785-9618 right now to schedule your tax-deductible vehicle donation and make a positive impact on the environment while helping others. Heritage for the Blind, where every car donation counts and every person makes a difference. Call 1-800-785-9618 now.
Back in the Legal Lounge. Thank you so much for joining us here. We really appreciate it. We're talking about Justice Thomas, Justice Brennan, and also substantive due process,
Yes.
procedural due process.
Thank you.
And please continue, Richard.
Thank you very much. So we've just decided, or we've just explained that the 14th Amendment 14th Amendment Due Process Clause, 1868, that was directed toward the states. Remember, it says that no state shall deprive a person of life, liberty, or property without due process, that it was strictly a procedural thing that the states were heretofore ordered to acknowledge. Now, this is why Justice Thomas is a bit upset with what he calls substantive due process, because what the Supreme Court did through a number of doctrines, which my partner here will elucidate on in a minute, they started adding substantive crimes, that is to say, or offenses, that is to say that if you do go through a stop sign, you might end up spending a day in jail and being fined $200. That is substantive law. It has nothing to do with procedure. And again, I'm repeating, but the due process clause that says no state shall deprive a person of life, liberty, or property without due process, it is concerned only with procedure, not substantive law. And this is why I claim that the Supreme Court violated its own sphere of influence by adding substantive law to the 14th Amendment Due Process Clause.
Let's hear some language real fast from another skeptic of substantive due process. Oliver Wendell Holmes.
There you go.
He's a proponent of legal realism. He worried the court was overstepping its boundaries and wrote in a 1930 decision in one of his last dissents.
Yes.
I have not yet adequately expressed the more than anxiety that I feel at the ever-increasing scope given the 14th Amendment in cutting down what I believe to be constitutional rights of the states. As the decisions now stand, I see hardly any limit but the sky to the invalidating of those rights if they happen to strike a majority of this court as for any reason undesirable.
Yes.
I believe that the amendment was intended to give us carte blanche to embody our economic or moral beliefs and its prohibitions, yet I can think of no narrow reason that seems to me to justify the present and the earlier decisions to which I've referred. Of course, the words due process of law, if taken in their literal meaning, have no application in this case, while it's too late to deny that they have been given a much more extended and artificial signification. Still, we ought to remember the great caution shown by the Constitution in limiting the power of the states, and should be slow to construe the clauses of the 14th Amendment as committing to the court with no guide but the court's own discretion.
Yes, that's right. So he's given the courts carte blanche.
Yeah.
Now, this guy has a great name, doesn't he? Oliver Wendell Holmes.
Yeah.
I mean, come on.
Sounds like a detective.
If you're looking for credentials, brother, you've got it there. But here's the problem. Excuse me, but my boy TJ, Thomas Jefferson, he had a few things to say about the Constitution. And this is in Chapter 2, McCulloch versus Maryland. And the fact that John Marshall, an equally valorous Supreme Court justice, if you will, he said that the Supreme Court had the authority to overrule acts of Congress. This is clearly in the Marbury versus Madison case, not really in reality. However, this is what Thomas Jefferson said about the McCulloch case, 1819, that basically said that the federal government the Congress has the right to establish a federal bank. They do not. In any event, this is what Jefferson had to say. He had been president in 1803. He was no longer president in 1819. But again, this is what Thomas Jefferson said. That all powers not delegated to the United States by the Constitution, nor prohibited by the states, are reserved to the states or to the people. He's simply reciting the 10th Amendment. Now, what does it say next? To take a single step beyond the boundaries thus specially drawn around Congress is to take possession of a boundless field of power no longer susceptible of any definition. Wow.
That's good language right there.
Powerful words there. And he says the incorporation of a bank and the power assumed by this bill have not, in my opinion, been delegated to the United States by the Constitution. It simply ain't there. And that is what I go by. TJ is the best as far as I'm concerned.
Yeah, you and me both. Right. And stick around, Richard. We're going to talk after the break about some of these doctrines, these court-made doctrines made out of whole cloth. Right after the break, and how they affect us now and in the future.
I'm sorry, he had a couple slaves, but other than that, he was the best.
He was a man, man of his time. You can't judge a man outside of his own time. Stay
Absolutely.
From basement podcasts
is this thing on?
to social media.
I'm so funny.
These days, it seems like just about anyone can share their 2 cents. But with so many voices out there, who can you trust? Well, how about LA's first and longest running talk station? For over 60 years, AM 790 KABC has been the trusted source of news and information for Southern Californians from San Diego to Santa Barbara and beyond. With powerhouse hosts like John Phillips, Randy Wang, Armstrong and Getty, Frank Motek, Guy Benson, and Vince Colonnese, you can rest assured you'll receive the news of the day with honesty, insight, truth, and above all, facts. On air on AM 790, online at KABC.com, and on the go with the free KABC app for news talk you can depend on. Trust us. Fast-paced, fact-based, AM 790 KABC.
1 out of 2 Americans thinks their life is worthy of a book. Here's another startling stat. You may be one of the 15% of people who bothered to start your book, and one of the 6% that got halfway through it, but your gem of an idea likely died. Or did it? Some published authors are making significant money, so join the ranks of the successful people that finish their books with help from Dorrance Publishing. Call right now, and our experienced editors and writers will explain to you what it's going to take to get your book completely written, published, and then taken to market to sell it. It's a free consultation, so call right now. Find out how much time and money it takes to finally get that book idea of yours published. Make your dreams happen. Call Dorrance Publishing right now.
800-786-1468. 800-786-1468. 800-786-1468. That's 800-786-1468.
Are you annoyed, angry, or maybe there's another word you want to use about where your tax dollars are going? Let's face it, the government does a terrible job of managing money, especially when it's yours and mine. Tax dollars are being wasted, and all the government does is have their hand out for more. So what do? They send you, the tax-paying American or business owner, a letter saying you underpaid your taxes, and you owe us a lot more. Don't laugh and don't cry. Call the Tax Resources Network now. Their trained experts can help negotiate between you and the IRS and take all the stress off your back. And if you're lucky, save you a boatload of tax money. So before you think about calling the IRS, if you owe $10,000 or more in back taxes or you haven't filed in a while, call us right now.
888-816-7701. 888-816-7701. 888-816-7701. That's 888-816-7701.
It's time to rediscover Ka'anapali Resort on Maui. Goodbye stress and work. Hello paradise and fun. Restaurants, hotels, golf, spas, hiking, shopping, activities of all kinds, or just lounging on the beach and listening to the waves. Visit Ka'anapaliResort.com, Kaanapali Resort.com. Ka'anapali Resort on the west side of Maui.
Hi everyone, this is Ron Say. I played baseball for the Los Angeles Dodgers, Chicago Cubs, and Oakland A's. My Dodger teams won 4 National League pennants and a World Series. Now I am tackling a new challenge. I am hosting a new sports show called We'll See About That. We will look at the aspects of sports, baseball, football, basketball, hockey, soccer, and much more. Plus, you will be able to get my honest opinions on the big stories of the day. Join me for We'll See About That, Saturdays at 11 a.m. Pacific Time right here on crntalk.com.
So we are back in the Legal Lounge, having a great conversation about substantive versus procedural due process, also originalism, constructionalism versus the living, breathing document. And the living, breathing document, Richard, has gotten us some real doozies. And
it has.
Let's start with the first one. I know this one's particularly close to your heart, the exclusionary rule via the Miranda decision.
Exactly. And briefly, all the exclusionary rule means is this, that if the so-called sheriff blunders, that is to say currently, if the sheriff or police officer does not give the potential defendant Miranda rights, telling him that you have a right to, whatever you say might be used against you, you have a right to an attorney. If you can't afford it, we will provide one for you, et cetera, et cetera. This all comes from the so-called Miranda case and basically guarantees things to defendants that the Constitution, Bill of Rights and so on never intended. So it's another situation where the Supreme Court wrote law as opposed to interpreting law, and it's another star on the forehead, if you will, of Justice Brennan. But as far as I'm concerned, it's a paper star because it means nothing.
Yeah, Miranda decision, of course, in the early 60s really ran amok with the Warren courts. And, we talked about in the first segment about truth. And the exclusionary rule is almost anathema to truth because there's been countless examples, countless cases where the guy is obviously guilty. They got him obviously guilty by the facts. But yet, because of the, quote, error of the sheriff, and we're going to talk about harmless error later, maybe in the show, the convictions are overturned, criminals walk free.
That's right. And again, it's, as we said earlier, that freedom and liberty are very, very important. In fact, it's part of my book title. However, liberty or freedom without truth is kind of a hollow concept. And if the people who represent us and our senators and so on, if they're, if you will, crooks or crooked, we get just exactly what we have just elected, people who don't rely on truth for their decisions. And this is one of the reasons why I wrote the book, because there's too much, I don't know if we can call it honest falsehoods. It's kind of not punishable falsehoods, but technical falsehoods that I object to. And another example, of course, is New York Times versus Sullivan.
That's another decision made of the whole cloth in the mid-'60s by the Warren Court.
And that was simply a case where someone had defamed one other person, and we have laws concerning defamation in almost every state. In any event, normally, if a person defames you, says something false against you, and causes you some injury, you have a right to sue that person for damages, the same as if he had just punched you in the nose. However, what the Supreme Court did while the case was pending, frankly, and the plaintiff was winning the case, the Supreme Court said, wait a minute. When it comes to people who are public officials or public figures, it's not enough that what you say about them is false. You, the bad guy in this case, the defamer, you must have known it was false, and therefore what had been a win for the plaintiff became a loss.
You have to as the defendant act with actual malice.
Exactly.
And for the life of me, I can't figure out what actual malice means. And the rationale behind that decision was that if you're a public figure, according to the Warren Court, that you can defend yourself from these spurious claims of defamation because you, as a public figure, you have access to the media, access to so on and so forth. Correct. To get your defense out. But that makes no sense whatsoever because you've already been injured.
Of course you have. And the irony, too, is the plaintiff, while the case was pending on appeal, the plaintiff had just won the case.
Yeah, he did.
And what they did is the Supreme Court, changed the law mid-case. What kind of stuff is that? So they took a person who had been the winner and made him the loser.
Yeah.
Outrageous.
Absolutely outrageous. And Clarence Thomas, no fan of New York Times for Sullivan, and he says that decision needs revision, similarly to...
and one that comes to the mind again, burning of the flag. Where the hell did this come from? 48 states plus D.C. said no burning of the flag. This was before Hawaii and Arkansas and Alaska had become states. Every state had a punishment for burning the flag, yet the Supreme Court came along and said, wait a minute, that's just an expression of your First Amendment freedoms of speech. Where the hell's the speech in burning anything? You don't need to burn the flag to use the speech. Therefore, it's another case. It will be reversed, and I'm saying that the southern states are going to now start punishing people for burning flags, and it's eventually going to hit this more conservative Supreme Court, and we're going to put it back to where it was. We're going to do the same thing we did with Dobbs, and in fact, I'm going to coin a phrase, let's Dobbs it.
Let's Dobbs it. Of course, you're talking about Texas v. Johnson, 1989, and like you said, 48 out of the 50 states already had laws on the books punishing or criminalizing desecration of the flag.
But Brennan and his guys knew better than all these people.
Apparently so. This was William Kunstler, of course. He was the representing the plaintiff in this case.
But Mike, what comes to mind again is this is exactly what the Democrat Party of today is doing. They have their own theories and doctrines that they think are wonderful for the people, yet the Republicans are simply basically giving the people what they want. So is there any contest as to who is going to win the election, giving the people what they want that is proper, or doing what some professor has decided in his laboratory that we should have or we should take?
Let's hear some language from Texas v. Johnson from Rehnquist's dissent. Of course, Texas v. Johnson was the flag burning case, which pretty much lets anybody, any long hair out there, burn the flag. Here's Chief Justice Chief Justice William Rehnquist's dissent. Quote, "The American flag then, throughout more than 200 years of our history, has come to be the visible symbol embodying our nation. It does not represent the views of any particular political party, and it does not represent any particular political philosophy. The flag is not simply another idea or point of view competing for recognition in the marketplace of ideas. Millions and millions of Americans regard it as almost mythical relevance, regardless of what sort of social, political, or philosophical beliefs they may have. I cannot agree that the First Amendment invalidates acts of Congress and the laws of 50 states, which make criminal the public burning of the flag."
Exactly.
You got it in the head. All right, Richard, we're going to come back right after this break. We got a couple more of these whole cloth doctrines made, and I think two of the most important ones we're going to talk about: incorporation doctrine and judicial review via Marbury versus Madison. Stay with us.
This is baseball's Ron Say. Nowadays, it seems like nothing is built to last. Phones, appliances, cars, computers, but the new Michelin Defender 2 tire is designed to outlast. With a quiet and comfortable ride, you will have the confidence you need on the roads, whether they're wet or dry. So goodbye to the short-lived and hello to something that lasts. Get your set of Michelin Defender 2 tires at Hank's Tires, 19951 Ventura Boulevard in Woodland Hills. Call my buddy Steve Goldberg at 818-340-4200. That's 818-340-4200. Hank's Tires is also built to last. Hank opened Hank's Tires in 1953, and we are the oldest tire and auto repair shop in the San Fernando Valley with 100% customer satisfaction. Hank's is AAA approved for all of your auto repair needs. Call Hank's Tires at 818-340-4200 and tell them Ron Say sent you.
You order a glass of your favorite Cabernet, fresh asparagus, hollandaise on the side, a filet, medium rare. You unfurl your napkin with a flair, close your eyes, and prepare to listen. Ah, there it is. The sweet music you long to hear. The sizzle. The sizzle of a Ruth's Chris steak.
The most magnificent corn-fed prime beef, broiled to perfection at 1800 degrees. Some call it a sizzle. We call it an anthem.
As the waiter approaches, you think, is this one mine or that one?
Ruth's Chris Steakhouse. Like Ruth always said, life's too short to eat anywhere else.
Make a reservation online at ruthschris.com or by calling 800-544-0808.
And we are back in the Legal Lounge, Searing Digital Talk Radio, SearingTalk.com. Make sure to check out Richard's fantastic book, America, An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. And when we first started doing the show together, Richard, I read it. And, you know, there's so many fascinating information in there and so much I didn't know that affects day-to-day life now, going all the way back to nearly the founding of this country, all the way back to 1803 with a case that you write extensively about, that you've researched extensively, called Marbury versus Madison. Why is that case so important?
Well, because it's 1803. It's like the Constitution was 1789, Bill of Rights 1791. 1803 is what, 13 years later?
Yeah,
something like that, okay? The Constitution was just barely had dry ink when John Marshall, who's been hailed by both sides, Democrat, Republican, liberal, conservative, as one of our finest jurists. However, what he did was so absolutely amazing because what he basically said is that the Supreme Court, being closest to the law, it has the right to determine what the Constitution says and whether or not the Congress has said something that is contrary. That is to say, that the Supreme Court has the power to void acts of Congress. Now, let me read one very brief thing here. This is a quote from John Marshall, 1803, from the Marbury versus Madison case. He says here, the powers of the governments are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written. Now listen to that. Reflect on that for a minute. That these limits may not be mistaken or forgotten. The Constitution is written. So he says pretty much you have to go by what is written there so you don't forget it or mistake it. Okay. To what purpose are powers limited, and to what purpose is that limitation committed to writing? if those limits may at any time be passed by those intended to be restrained. The distinction between a government and a limited and unlimited power is abolished if those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested, and the Constitution must be controlled thusly. So he's saying right here that if it ain't in the Constitution, you're not bound by it. You can't follow laws that are not in the Constitution. You are bound to go by what is written there, and it's written there so you don't forget or mistake what's there. However, in his next breath, he says, the Supreme Court has the authority to void acts of Congress. And I'm saying, where the hell does that come from? It ain't in there. It's just unbelievable.
Well, Richard, he felt bad about that. He felt bad that he pretty much said that the Supreme Court is now the supreme law of the land, saying that they can pretty much void acts of Congress and, fundamentally void acts for the president as well. But he felt bad about that. And so what he did is then a couple of years later, in 1819, McCulloch versus Maryland, he says, all right, Congress, I came in there and I said that I can pretty much void whatever you did, but now I'm gonna go ahead and I'm gonna read the Constitution and I'm gonna go through to Article 1 and I'm gonna look at the enumerated powers of Congress, and I'm gonna go, hey, you got all this stuff here about post office and about meetings and stuff like that. You got, I believe, 16 or 17 of these enumerated powers. You know what I'm gonna do? I'm gonna make this last one, the necessary and proper clause. I'm gonna allow you guys to do whatever you want.
Basically, that's what he did. He took the necessary and proper clause, which basically said, it's number 18 of the Bill of Rights. And what the necessary and proper clause says is this: the first 17 are express powers that the Constitution has given Congress. They have the right to coin money. They have a right to deal with the Indians. They have a right to
declare war.
Exactly. Yeah. 17 different things. Now, establish a post office and post roads. Now, number 18 says that they can do whatever the necessary and proper clause basically says they can, in addition to those 17 express powers, have the implied power to do whatever is necessary and proper to carry out those first 17. So, if one of them, I think it's from Section 8, I think it's number 4, the power to establish post offices and post roads, that would very well mean that the federal government has, under the implied power, the power to purchase property, to build a building, to do whatever is necessary and proper to be able to have a post office. Now, what did Justice Marshall do? Because what the federal government, Congress, wanted to do was to establish a national bank, and Thomas Jefferson had already voiced his opinion, saying you don't need a national bank. We're doing just fine in the states, thank you. So what did the Chief Justice Marshall say? Having won big time in the 1803 case, granting the Supreme Court power over the Congress, what did he do? He said, well, you know what? The bank is not even mentioned in the Constitution, and incorporation is not mentioned in the Constitution. However, I find that the bank can incorporate a federal bank in the Constitution. Therefore, I'm granting Congress the authority to establish a federal bank that's or to incorporate a national bank. In other words, he went from negative to positive again, which is, I guess, why so many people think he was so wonderful. Because how the hell did he do it again? He simply says, basically, the Constitution doesn't even talk about banks, and it doesn't talk about incorporation. Yet he okayed the national bank,
the founding of a national bank, saying that after saying that he wasn't going to. Stick around, you guys. We'll be right back. Stay with us. Wrap things up.
Areas of pain promote fast, natural healing. Relax your muscles, ease muscle spasms, joint stiffness, and arthritis pain while increasing blood circulation. For over 25 years, Dr. Sheps has helped Olympic athletes and sports enthusiasts alike get back in the game. Schedule your visit with Dr. Sheps at his Brentwood office in California. Call 310-873-4422 or visit at drsheps.com. That's DRSHEPS.com. 310-873-4422. The Kahanapali Beach Resort on Maui is open, and we are welcoming guests. All properties are taking reservations now. Come visit. Go to kahanapaliresort.com. Experience Kahanapali Beach Resort on the tropical west side of Maui, just a short drive from the airport. All highways are open, a collection of relaxing resort properties, our award-winning beach, delectable dining, world-class restaurants, and activities for everyone. Snorkeling, surfing, sailboating, water sports of all kinds, beach and ocean dining, stargazing, beautiful sunsets every night, golf, sun, fun, food, wine, and all in paradise. Visit Kahanapali Beach Resort on Maui. Relax. Reservations are now available. Start with a visit to kahanapaliresort.com. That's KAANAPALI resort.com. The Kahanapali Beach Resort is waiting for you.
Attention, those of you looking to go on a fun vacation and see the world on the cheap. Today, the U.S. dollar is worth even more in other countries, so there's never been a better time to travel outside the USA. The dollar is worth over $1.30 in Canadian dollars, and it's the same for Australia. You can fly there today and have fun and maximize your travel dollar. Your U.S. dollar is worth over $3 in Brazilian reals, and it's worth over $18 in Mexican pesos. Plus, in Argentina, it's worth over $27 in Argentine pesos. Just think of the bargains you'll get. And the way you get the cheapest airfare to any destination is by calling Tickets That Cheap. Save up to 75% on your foreign vacation tickets. Don't wait. Call now.
802-317-1979. 802-317-1979. 802-317-1979. That's 802-317-1979.
We're back at the Legal Lounge. Thank you so much for joining us. Richard and I were just talking during the break that if I was a sitting congress member or senator between 1803 and 1819, I'd be hopping mad.
I'd have been an Aaron Burr looking for Hamilton.
Yeah,
right now.
I would have been wanting to duel on the lily pads outside of Washington, D.C. because between those 16 years right there, Chief Justice John Marshall said to Congress pretty much, whatever you guys do, we can stop.
Right. And again, these are the words of John Marshall in the McCullough versus Maryland case, 1819. And this is what he said, and I thought I quoted it pretty well. Among the enumerated powers, we do not find that of establishing a bank or creating a corporation. Now, isn't that amazing? Neither one of the issues is in the Constitution, yet he flipped it around and said something like, well, yeah, wait a minute. Do we want to really embarrass the federal government? After all, they coin money and they do all kinds of things business-wise and so on. Is it really unfair for them to incorporate a national bank? Well, according to Jefferson, yes, because the states were doing just fine, thank you. Now, so what did we really do? In 1803, Marbury versus Madison took power from Congress, gave it to itself, that is the Supreme Court, saying that the Supreme Court could void acts of Congress. However, feeling some puncture of tincture or whatever, some pain, he waited till 1819 and the right situation came up, McCullough versus Maryland. And what did he do? He said when Congress wants to pass a law, they don't have to limit themselves to what's necessary and proper. They can do whatever is convenient or appropriate. That's good enough. Pass anything you want. Carte blanche.
Yeah, convenient and appropriate was the language, and it's
However, one last thing. John Marshall finally did come through with a good decision. 1833. Which one was it?
1833. I have to look that. I know this is I'm failing the test here. 1833. John Marshall.
Something versus Baltimore.
Barron versus Baltimore.
Got it.
Barron versus Baltimore.
He said that the Fifth Amendment did not apply to the states, and basically that the Bill of Rights did not apply to the states. 1833.
Well, Richard, and then he retired, but yes. A new Supreme Court came into effect, mostly appointees of different presidents, and the Supreme Court is going to get what they want. And so in 1803, they said, hey, we can invalidate federal law, acts of Congress. And 1868, we can now void state laws.
Exactly.
But that took a while to germinate, though. That took a while for until the
Here you had guys from 1940 looking back to 1868 and claiming they knew what happened in 1803. All put that. No mathematician. Einstein could not have figured out that formula. No way. They just made it up.
They made it up. And so now, through the incorporation doctrine, they reached back in the 1930s. They reached back to the Due Process Clause of the 14th Amendment and said, hey, now we can use life, liberty, and property, and that applies to the states. Now we can apply the Constitution, the Bill of Rights, to the states.
We can what's the word I'm looking for? We can micromanage the states. Yes, we can. Whatever they do, something wrong, we can claim they violated the Fourth Amendment, the Third Amendment, the Fifth, whatever. So the Supreme Court has put itself in charge of the whole country.
And that's hence why America is an illusion of freedom. When you have,
thank you very much.
When you have justices,
we don't have the total freedom, and we won't until we, agreeing with Judge Alito, Thomas, and maybe some others, we're going to get rid of substantive due process.
Yep. Richard, we're out of time. Maybe we can talk about the dormant comment clause next time.
Oh, my God,
absolutely. That's another good one. That's another way that we have an illusion of freedom. But, Richard, thank you very much. A true tour de force today. So thank you guys for joining us. Really appreciate it. Make sure to check out all past and previous sessions available on YouTube and Rumble. Find Sierra Digital Talk on both those platforms. And also, as always, make sure to check out Richard's fantastic book, America, An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. And we'll see you guys next week here in the Legal Lounge.
Are you tired?